How the contractor deals with force majeure. Can COVID-19 pandemic be considered as a force majeure? Force majeure, which is a French word that is used for the identification of a superior force, meaning an event or an effect that can be neither anticipated or controlled. It is also unexpected and prevents the party from performing or completing its obligation that it had agreed to do originally and as planned for. It can also be defined as a superior or irresistible force for an event, effect that cannot be reasonably be anticipated or controlled. In modern business practice, force majeure clauses are generally embodied in the form of contractual provisions, agreed upon between the parties to excuse non-performance of contract in cases of events beyond their control, such as an act of God, natural calamities, war, labor unrest, epidemics, pandemics, etc. The FIDIC standard conditions has recognized and provided a detailed definition for force majeure, pursuant to Clause 19.1 of FIDIC 1999, which provides 4 conditions which must all be met for an exceptional event or circumstance to qualify as force majeure. The first is that the event should be beyond a party's control. The second is that such a party could not reasonably have provided against before entering into a contract. Thirdly, such an event which have arisen, such party could not reasonably have avoided or overcome. And finally, such event is not substantially attributable to the other party. These conditions are similar to the conditions for an unexpected circumstances which are included in the civil codes of some countries. FIDIC has provided a non-exclusive list of 5 examples to force majeure, all of which are events which are outside the control of either party. The list is significant, as contractors' right to claim for cost as well as delay depends on the category of the force majeure, as provided for by subclause 19.4. For the party to be excused from performing some obligation, and then it must be prevented from performing that particular obligation by a force majeure. All other obligations which are not prevented by force majeure must be performed as required under the contract. If the contract is completely silent on force majeure clause, it cannot be implied, nor the law to imply in it. However, in such case, there is a high potential to introduce or to apply the frustration of contract principle. In case of express or implied terms of force majeure in the contract, the consequences are set out therein, would follow upon proper invocation of the stipulation. Typically, the force majeure clause provides for the right to terminate the contract, suspension of a contract during the substances of force majeure event, waiver of damages or penalty for non-performance, change in consideration, etc. The consequences, like a force majeure clause, can be tailored suited as per the agreement between the parties and the object sought to be achieved under the contract. What I have mentioned is subject always to serving a proper notification of a force majeure as being followed in the standard FIDIC conditions. In terms of COVID pandemic in the United Arab Emirates, businesses operating in the United Arab Emirates must pay careful attention to the wording of their contracts and refresh their knowledge of the law before they seek to rely on a force majeure clause in response to the COVID-19 pandemic. For example, these contracts agreements that are drafted based on FIDIC standards as their general conditions cannot refer to pandemic as a force majeure, for a simple reason, that is, the works were not hindered or stopped totally. The government in UAE, including Municipality of Human Resources and Labor Department, have issued subsequent memos as how to deal with pandemics, which has applied more liabilities and duties on the contractor to follow. However, did not affect the full scope of the work to stop and to become standstill. There are a number of questions that every business should be raising, no matter the stage of contractual performance. Is the performance of the contract embedded? Is the contract now impossible to perform, or is it merely more difficult? Does the contract include an explicit force majeure provision, which need not to be labeled as force majeure? And if so, is the embedment caught by that provision? Does the contract require notice of a force majeure event to be given and has notice been given accordingly? How is embedment measured? How long will it last? And when can it reasonably be said to have ended? Is there any indication in the terms of contract that one party has assumed the risk of not being able to perform in the current circumstances? Is the embedment due to an event under one's party's control? Can one party reasonably have mitigated or avoided the consequences of non-performance altogether? Can the embedment be dealt with by cooperative means, including expressly varying the contract to accommodate the change? Whether or not the contract contains a force majeure clause, what is the governing law of the contract? And what does the law say about force majeure or similar doctrines? Where a business is entering into a new contract, how does it intend to allocate the risk of non-performance caused by the pandemic? Perhaps the answer to my previous questions can allow the contract administrator or claims consultant to be in a better position as how to deal with the situation and secure the contractual right of the contractor, irrespective whether or not the event or reason of delay was classified as a force majeure. Whether you need help with claims, disputes, or drafting, reviewing, or managing contracts, we can help. Click the link in the description for a free consultation and find out how Pioneer can help you today.